May it please the Court?
Yes.
Andrew Berman, Special Assistant District Attorney on behalf of the Commonwealth. At council table is Charlotte Bednar and Peter Carr on behalf of the defendant, William O'Connell. Excuse me. I'll be addressing the issues relating to the statutory interpretation of 97D in Chapter 276, 2B, and I'll try to address the issues raised by Justice Lank in the report and reservation. The first of which is whether or not affidavits supporting applications for search warrants and the accompanying search warrant materials in cases involving allegations of rape and sexual assault constitute reports or conversations within the meaning of Chapter 41, Section 97D. I think that it's eminently clear that a report is a report. If that exact same affidavit in support of the search warrant, which was submitted to the clerk magistrate, existed in the police file at the police station, I don't think anybody could reasonably question that that is a report within the definition of the statute, and it also contains conversations which will be covered by 97D as well. The legislature made it very clear by using the terms all reports and all conversations that the statute should apply to exactly that. The statute does not limit itself to official police reports in the possession of the police department.
Well, you say that, but the language of the statute says, and shall be maintained by the police departments in a manner which will assure their confidentiality. The legislature knows the word courts, didn't use the word courts, spoke only of the police department. Why is it not appropriate to say that this says that police reports in the possession of the police department are not subject to the public records law?
Well, I think, first of all, because that's not what, respectfully, Your Honor, the statute says.
Show me where it says anything other or means anything other than that the public records law shall not require the disclosure of these police reports, and they are not subject to be disclosed pursuant to the public records law. When the language of the statute specifically says shall be maintained by the police department, what do we do with that language?
Well, I think there's a difference between imposing a restriction on police departments and concluding that that is the only restriction in place, because once they're determined to be non-public records, there's a litany of procedures and statutes and case law governing non-public documents once they're submitted to the court. So for the legislature to make a specific reference to the obligations of police departments in maintaining these records, I don't think has any bearing on the well-established obligation of courts and prosecutors and defendants to ensure that non-public documents are not disclosed. I think the reason, to answer your question directly, that specific sentence is in there is because there is no existing case law or statutes relating to documents within the possession of police departments, while there is ample case law and procedures relating to non-public documents once they're deemed to be non-public.
And that case law says that documents are presumptively public, and you're saying that this statute is intended to override our common law regarding the presumptive public nature of filed documents. But that doesn't do so terribly clearly, so doesn't that mean that we don't infer that the legislature intends to change the common law unless it does so more clearly than this statute does?
I don't think that the legislature can get any more clear than saying all reports and all conversations. Yes, the 276, Section 2B, does apply very generally to affidavits in support of search warrants, shall not become public documents until the affidavit is returned. But that, respectfully, Your Honor, needs to be interpreted in the context of a later enacted, more specific statute of 97D. The legislature could have used terms official police reports, all reports in the possession of police departments while maintained at police stations. The court did not do that. And I think that one of the cases which we cite, Montefusco, and I know it's not directly on point, but it's in the brief for the proposition that 97D applies to something other than reports that are in the possession of police departments, because the reports in question in Montefusco, if there even were reports at all, relate to documents that were in the possession of the district attorney. So I think this court has, at least in passing...
Do we know what the nature of those reports was in Montefusco?
We don't, Your Honor.
So they could have been police records that were in, these kinds of records that were being maintained by the police department that the district attorney would have had access to.
I'm not sure I completely understand your question. My understanding of the documents that would have been in play in Montefusco would be the documents that would typically be involved in the course of a criminal case. Everything from...
But you don't think they were 97D type documents?
I don't know, is the answer to your question. I don't know if what the district attorney had in his possession was affidavits in...
Not affidavits, records or conversations that the police would have had to maintain under 97D. I thought that was what you were citing Montefusco for. Well,
I was citing Montefusco for the proposition that 97D does apply outside of a police department.
So these would be 97D type documents, is what my point is.
I believe
you presume that's the case.
I presume by the court's reference to 97.
That somehow those 97D documents were then in the possession of the district attorney.
Sure.
Because the district attorney could have access to what the police department has access to.
Precisely, and presumably there would be police reports, official police reports, in the possession of the district attorney relating to Montefusco's underlying case.
And so what we did was basically say those don't have to be turned over as part of a public records
I think the court ruled on other grounds, and that is that it was a post-trial motion and the defendant had not met the burden of the rule in obtaining those materials. I think in all fairness that language in Montefusco could be classified as dicta, but I do believe that the court's reference to it in the context of somebody attempting to obtain materials in the possession of a district attorney would counsel towards the interpretation of 97D as applying to something beyond just reports within the possession of the police department.
Can I ask you to follow up on the statement I think you made before, which is that there's ample case law and procedures dealing with non-public documents. So these are documents that, could you tell me what you mean by that?
Well, there are statutes in place. There's a uniform procedure for impoundment of documents, Your Honor. There are statutes in place relating to redaction of the name of a victim of sexual assault. There are statutes in place governing information.
This is what happens with this. I'm sorry, but I mean, are these things that relate to documents that are filed with a court?
Yes, yes, documents within the possession of the court, which by statute, various statutes, are not public documents, are not disclosable, are kept confidential. And just as an example, I'm sorry.
No, go ahead.
So just as an example, there's 258B section 3H, the residential address and telephone number or place of employment, and various other information relating to the victim or the victim's family member is by statute, if the victim so moves, not disclosable. There is General Law, Chapter 272, Section 105. Photographs of an unsuspecting nude person are not deemed to be public documents.
But following up on that question, would you have to say that 97D applies to, let's assume this search warrant affidavit is filed in the court. Is it not possible to implement whatever might be the applicable statutes that you're now referring to without ever getting to 97D?
Because 97D is much broader than the statutes that would normally apply in the context of sexual assault.
So I guess I'm just clarifying. You're not suggesting that the only way you get to those other statutes is through 97D?
Not at all. I'm just saying that there are laws that relate to the impoundment of documents in a court that I think reasonably could have led the legislature not to address that specific point in 97D and only limiting the last clause of that sentence to police reports maintained in the possession of police departments, because the procedures are well established to obtain an impoundment order in court. You simply file a motion and you cite the relevant case law and statute. I don't think that it was necessary for the legislature to include information that would carry 97D over to the courthouse, because those procedures and regulations are well established.
But isn't another way of looking at that 97D wasn't intended to apply, and that the remedy is through those other statutes?
Well, that's the question. The other statutes would not be as
I understand that, but
would be more specific as 97D. I mean, that's exactly the question. Does something that is a report in a police file somehow transform into something else as it's being transported from the police station to the courthouse? If it's a report, then it's a report then and forever. I don't see respect.
But it becomes an affidavit, and maybe the affidavit has things in it besides what's in the report.
It's the portion of the affidavit that relates to a report or conversation that I think is at issue here. I mean, the officer's rendition of their experience, I would concede, would not be governed by 97D. It would have to be something that's specifically set forth in the statute, all reports and all conversations relating to an actual or attempted sexual assault.
So
Excuse me, I'm sorry. We're 2 minutes over. Your
Oh, my
time is
apologies,
up.
Your Honor.
It's been over for a while.
My apologies. Thank you.
All
I
right.
didn't take note of that. I'm sorry.
May it please the court. Peter Carr, representing Mr. O'Connell. The district court did not properly apply the factors of where. The court focused on publicity, the size of the community, and the need for public access. This is not a First Amendment case. There are no First Amendment rights at issue. Certainly concede the public access to court records, but under where and the court's decision in where, the issues of the Sixth Amendment rights of Mr. O'Connell trump any common law rights that may apply to the public access to that affidavit.
Well, I mean, I understand that if there were but the judge here is probably closer to the idea of, closer to understand the danger of unfair or publicity making it impossible to choose a fair jury. But the judge decided here that that risk was not such as to require the impoundment, and indeed, there is already a substantial press about the case, including an article in Boston Magazine, which goes into some graphic detail with regard to it. So why is there an abuse of discretion by this judge with regard to his finding?
First off, Your Honor, to address the latter part about the additional publicity, that's not to be considered. What has to be considered is the state of affairs as of August 4th, 2011, when the court ruled on that impoundment
The article
order.
was after.
Far after,
okay,
and there's a number of records and a number of documents in the record, particularly through the amicus brief, that post-date that decision. So we can't consider the state of the world after August 4th. We consider it as of the date the court was making that decision. And on that date, for the court to find that publicity would not be adverse, it would not create a problem for a fair trial, is just wrong. Where says that it's virtually impossible to avoid prejudicial pretrial publicity at this early stage of the proceeding, the investigatory stage. There was no indictment at that point in time. The case was still under investigation, and that's right from the words of the court. The district court just ignored that and said, well, we can fix it. We can fix it later. There was no specific finding, Your Honor.
The fact that there was no indictment, are you saying that it would have affected the grand jury's evaluation of the case?
No, I'm saying that the court in this court has acknowledged and where that the preliminary investigation stages of a case, the investigatory stages of the case, that the impact on the rights of a fair trial is greater.
Right,
And so,
but I want you to be a little bit more precise as to what the impact would be on him precisely. You're saying it would not affect the grand jury's deliberations. I think from having reviewed the sealed affidavit, does not disclose investigative methods, doesn't reveal any informants or undercover agents. So it really comes down to whether or not it would affect the ability to choose a fair jury when this case comes to trial.
well, certainly it would affect, if the material in that affidavit gets out into the public, some of it would never be admissible, suppressible, multiple level hearsay, multiple sources, very low standard for probable cause, all of the factors that the Ware court considered in finding that the court properly exercised discretion in that case. There is a grave danger, if that gets into the public domain, to the fair trial rights of this defendant at this early stage of the proceeding. I don't know if it would impact the grand jury. I can't sit here and speculate who would hear what, but it certainly could have an impact on the trial proceedings going forward. And this information, there's no harm to the media, because when this affidavit, if it's ever used, or the information in the affidavit becomes part of an integral part of the proceedings and becomes part of the public court proceeding, then they can report on it. So there's no harm. What you're weighing here is the harm, the raw harm to the Sixth Amendment rights that this judge had an absolute right to protect and preserve, and not just say, we can do it later. There had to be an affirmative action taken by this court to ensure that those Sixth Amendment rights were not invaded, and the court did not do that. Just found that we can fix it later. If the fix it later standard were the standard, Your Honor, then there would never be any basis for impounding based upon a Sixth Amendment right. And that's not the law of the Commonwealth. Where it establishes that clear and simple, at this early stage of the proceeding, the Sixth Amendment rights trump the rights to any public access. It's not an integral part of the public knowledge. There is no public right to know what's in that affidavit. And later on down the line, when the taint may have dissipated to the fair trial rights of that defendant, then the public can have a right to information. But there's no harm to the public here whatsoever, Your Honor.
I should remember this because I did read the Ware case, but is one of the, this isn't your argument, but is one of the reasons, because it's a search warrant affidavit, that one might say this shouldn't be public is because the investigation may or is still ongoing? I mean, at the time that it is filed?
That's exactly right, Your Honor, and that is in Ware. It's part of Ware and it's part of my argument. At the time, on August 4th, when the court made that determination, the indictment had not yet been issued, and the investigation was still proceeding. And that information would have been into the public domain. That's a problem.
For you, but for the DA.
It's for me, too, because at that point in time, what the public gleans from that information, particularly the nature of the information, the way it's conveyed in that affidavit, the multiple levels of hearsay, and you can see the fervor that is surrounding the publicity of the case. And I'm not saying you close the courtroom, but you got to protect the rights.
Is your argument the same if the criminal process had issued and during the discovery phase the Commonwealth sought a DNA sample by motion from the court and attached to it the report?
My argument would be the same. That's correct. It's still in the investigatory stage, and I think that's probably the Republican, similar to the Republican company case, where Levine, I think the facts in that case involved a DNA or blood sample, if I remember, I don't know if it was blood or DNA, but that case was exactly that issue. And in that case, it was impounded, it was modified, it was reversed in 1996. An appeals court single justice said, no, we're not going to lift the impoundment order. And finally, it was lifted. And the reason, in large part, if you look at the end of Republican company, in large part because the investigation had concluded. It had terminated, in essence. That's not the facts of this case. And frankly, I understand my time's up, Your Honor, but if I may just finish up on this point, there's a heavy reliance on the Sharp case. And there's some reliance on a case that Justice Gantz wrote below in the trial court. Both of those cases, Your Honors, those were civil cases. The Suffolk County case was a civil case in the nature of a civil case. The Sharp case was access to materials that were filed in a civil domestic relations case, affidavits by the abused spouse. They are not search warrant affidavits. The cases are absolutely distinguishable. And if you read closely the Sharp case, you'll see the court focused on the civil nature of those affidavits and the fact that there was a First Amendment right that applied and attached because there's a general historic openness of a civil proceeding such as a 209A proceeding, and the legislature even said they're not confidential. So Sharp is not controlling. Ware is controlling, and I think the court takes great guidance not only from Ware, but the results in Republican Company that occurred prior to the case reaching this court. If there's no other questions, Your Honors, I appreciate the court's time.
Thank you.
Thank you, Your Honor.
Good morning, and may it please the court. I'm Mike Greigel from Greenberg-Traurig, and with me this morning is Zachary Kleinsasser. We represent George W. Prescott Publishing Company, which publishes the Patriot Ledger newspaper in Quincy, Massachusetts. I'm going to address Mr. Berman, the special prosecutor's statutory argument first, but before doing so, I'd like to present a quick framework to the court that I think is important both to the statutory question and to the underlying good cause determination analysis. First, it is unequivocally clear in the Commonwealth that there is a presumptive public right of access to search warrant materials by statute under Section 2B, Chapter 276, which expressly holds that after execution of the warrant and upon its return and filing with the court, it is a public document presumptively. Number two is this court itself held in the Ware case in 1988. There was a recognition that search warrant materials, again, are subject to a presumptive right of public access, not just by the statute I just referenced, but also as a matter of common law. Ware does not hold, and this is one point I really want to urge on the court, that there is an all-encompassing rule that there is no determination of, no support for a good cause determination in the context of a search warrant affidavit issued early in the context of a criminal case. Ware holds, as does the Sharp case, as does the Republican Company case, as does every precedent this court has issued on the common law right of access to judicial documents in the last 15 years, that there has to be an individualized determination of the relevant good cause factors based on the facts of the individual case, subject to the discretion of the trial judge. There are no per se categorical rules. That's exactly what happened in this instance.
Okay, well, let me ask you this. You've not seen the affidavit, I gather, because it's still impounded.
We would like to, Your Honor, but we have
you've
not.
Okay. If the affidavit were to identify the child alleged sex victim or provide information which would permit somebody relatively easily to identify her, would you agree that that would constitute good cause for at least the redaction of that information?
Well, I think depending on the circumstances, it may, Justice Gantz. In most cases, I would agree with you, it likely would. But the answer to that is in the decision you yourself wrote in 2002 in the Globe newspaper case. It's not wholesale impoundment. It's let's carefully redact the name of the victim and any identifying information to the extent necessary to conform with the narrow tailoring requirement that is part of the good cause determination in this Commonwealth. And again, that's exactly what Quincy District Court did in this particular instance. There may be, I admit it's perhaps unlikely, but there could be a case where a victim doesn't oppose disclosure. And for a per se rule to prevent that would make little sense in the application in that particular context. Let me turn to the statutory argument. First of all, it's a novel argument. There's no case law authority in the Commonwealth that any of the parties have been able to find. And that's because Judge Zimian below correctly determined there is no conflict. Turning to the plain language of the statute, Justice Gantz, you began by questioning the special prosecutor with this. It says, shall be maintained by police departments. The language seems fairly clear to me. The legislature knows how to abrogate or suspend rights of access in specific contexts. Coming to Justice Botsford's question, they did so exactly in enacting Chapter 265, Section 24C, which says court records where there's a sexual offense or a rape victim The name must be kept confidential. The legislature knows how to engraft exceptions on well-established rights of access. If they had wanted to do so here, one would have thought they would have been clear.
But the statute also says, you know, if you read it, all reports of rape and sexual assault and all conversations between police officers and victims concerning these offenses shall not be public reports. That's also what it says, in addition to, and shall be maintained by the police department.
It does, Justice.
So, I mean, we are faced with the problem of that the legislature said that all reports and all conversations, and to the extent that an affidavit, a subsequent affidavit, contains those conversations, is that something that is not a public report?
I don't believe it is, Justice Lank, and the reason for that we touched on when we were before you in September. I think there's a couple of points that necessarily come into play in response to your question. First, an affidavit isn't quite any longer an unmediated, raw presentation from a victim to a police officer.
Well, of course, neither, when you're talking about conversation, neither is a report.
That's correct, Justice.
But the statute uses the word conversation.
It does. And having seen some affidavits, search warrant affidavits in my career, they represent some degree of selectivity in review of the underlying raw police information, the reports from the victim and the conversations with police. Presumably after some degree of initial verification and investigation, to see whether or not the victim's story can be corroborated and is worth presenting to a judge and asking for a search warrant application. And it includes additional information. Usually the qualifications and experience of the affiant, of course a summary of the items that are going to be the subject of the search. But the relevant point is that once an affidavit, which includes police record information, even arguably within the purview of Section 97D, is presented to a court which reviews the information and then undertakes the very serious and significant business of adjudicating a matter that authorizes an invasion of the Fourth Amendment rights of the subject of the warrant, among the highest values, not just in the Commonwealth, but in the country, the nature of the document is transformed.
But can I just ask you this, though?
Certainly, Justice Botsford.
Does that mean that if the police are being true to 97D, that they are not permitted to put into a search warrant affidavit quotes of the conversation? Because, of course, that's the most persuasive stuff to get the affidavit. I mean,
Your Honor, our position is it certainly should not disable police and law enforcement investigative agencies for including that information. And they do so, and they will continue to do so. The point is that, again, I think it comes back to how you read the statute. It doesn't apply, in our view, to judicial records, and that is what a search warrant is, because you're asking a judge for a decision.
The police officer has this conversation. The statute, no question, applies to the police officer, right?
Correct.
So the police officer has this conversation, or, I mean, I could use as another example, let's just say there was a report attached to an affidavit. I mean, it's the same point. But the conversation is probably more realistic. So there's a conversation, wants to include it in an affidavit, is obligated by the statute to maintain it in the police department. Is the resolution here that we forget 97D as when it gets into that affidavit, that's the end of 97D?
I think the answer to your question, Justice, the answer was implicit in the question, Justice Botsford. The 97D applies to internal police department records, not just the language, but I think the structure of the statute gets you there. In any event, once the material is given to a court as the basis of an adjudication of whether to authorize a search warrant, the nature of the document is changed. And we have precedent for that. This Commonwealth previously, and I believe still has on its books, a statute that prohibited the press and the public from being in a courtroom during a trial of a minor sexual offense victim.
Right.
That statute would apply in this instance, where the victim is, we understand, 14 years of age. So, question, the argument is structurally identical to the one that's being urged on you by opponents today.
So wouldn't the answer, though, be, as in that case, at least if I'm remembering it correctly, this is the Globe newspaper case, right?
That's correct.
Wouldn't the answer be that accepting for the moment your point about that when you have an affidavit, it's, at least as far as the police report is concerned, it's not the same. But the conversations, one would redact the conversation from what
Well,
gets...
I think they can only be redacted, Justice Botsford, on a showing of good cause.
Oh, but I guess what I'm asking you is, why wouldn't that be implementing... I don't know how else you implement the conversation part of Section 97D, unless you just tell the police they can't do it.
Well, again, it depends on how you read the statute in the first instance, and clearly I'm reading the statute in a way that it does not apply to judicial documents as opposed to internal police files. And that resolves, I think, the dilemma that's the foundation of your question. But even if to the contrary.
You don't
Justice
see
Blank?
this statute as somehow being all of a piece with a larger legislative policy to protect the privacy of victims or alleged victims of sexual abuse and sexual violence?
I do agree with that, Justice Lank. Not
So I
wholeheartedly.
mean, but then what is the purpose, if it's only to be, directed at maintaining it while it's within, physical police custody, and it's not the information itself that's, because, other statutes, for example, cover the name and other what about rape counseling records and privileges and that pertain to that? It just seems to me that you can't read this statute as just off on its own, one little thing about internal police records.
Well, again, with all due respect, Justice Lank, I think the structure of the statute and its framework suggests that it applies to internal police records. But in answer to your question, and it isn't me just saying this, it's the United States Supreme Court. The answer is in the Globe newspaper case in 1982. And the very same purposes.
But that was the closure of the courtroom.
It was.
That's different than this. That has to do with the closure of a courtroom.
It does, but here we have court records, and as Justice Gantz wrote in his decision in 2002, in the other Boston Globe case, the analytical standard for determining whether there's press and public access to judicial documents and court records is identical to that, to closing the courtroom itself. And certainly there's no authority that I'm aware of, none issued by this court or any court in the country, that holds there's somehow a differentiated or bifurcated right to court records as opposed to the proceedings themselves. It's the same analytical standard. And again, Globe newspaper says the fundamental problem with the statutory construction argument being urged by my opponents on this court is that it would violate the First Amendment. Perhaps not in the search warrant context, because this court has held there is no First Amendment right. We're not challenging that. There is a common law right. But in other contexts down the road, it would certainly raise grave constitutional problems if it were applied. And I took it, Justice Lank, that was the point of your questioning to Mr. Carr back on September 22nd. You were looking for a temporal point, as I understood it. At what point does this come out? And you asked him, what about if the information within the purview of 97D is presented in a criminal trial? Is it sealed then? Of course, it can't be.
Well, is anybody claiming that this is a privileged statement?
I haven't heard that claim,
okay.
Justice Spina. No such claim. Okay. The arguments below in support of sealing, if you look in the record, and I believe it's at record page 13, the initial state trooper affidavit did cite Section 97D, and it cited ongoing law enforcement interests. The investigation was still continuing. That was taken into consideration by Judge Zimian in issuing the initial impoundment order on August 5th. He did consider those. And then as the argument went on, after 4 appearances by counsel, multiple submissions, he went through all of the good cause factors and made a determination based on the individualized facts before him that there was not sufficient good cause to justify the drastic remedy of impoundment based on the particular circumstances of this case. And he specifically distinguished where, as a case involving a small rural community as opposed to the metropolitan suburb in the greater Boston area of Quincy.
Now, along those lines, Mr. McConnell had been arrested, but there was no indictment, or there was a complaint filed, but there was no indictment as of the time of the order, correct?
That is correct, Justice Gaines.
Consequence, since he had been, a complaint had been filed, but the indictment had not been filed, does that affect the good cause determination?
Well, I think, in certain particular circumstances, conceivably it could, but no such showing has been made here. And in fact, Mr. O'Connell was arraigned on the charges against him. The Patriot Ledger and other news organizations reported on this. The nature of the charges are in the public domain. The fact that 19 grams of cocaine were seized from his condominium unit is in the public domain and has been reported on, which I think takes us directly into this court's holding in the Sharp case. And that, again, is a principle that was relied on. And I see I'm over. I have one very brief point, addressing the Sixth Amendment fair trial right. Judge Simeon in Quincy District Court, after hearing all of the submissions and taking all the factors into consideration, determined that it is the rarest of circumstances that we deny public access to court records based on an alleged infringement of the Sixth Amendment fair trial right. And why is that? It's because, as this court has repeatedly indicated in the Sharp case, among others, that other alternatives to ameliorate any alleged prejudice are sufficient rather than to deny public access, in particular, careful probing voir dire of the jurors. And having contended with Mr. Berman and Mr. Dolinsky, who's the chief criminal defense counsel in this case, I have no compunctions that there's not going to be a very adequate probing extensive voir dire in this case. And that is the preferred remedy, along with curative and admonitory instructions, worst case option, change of venue. Unless there are further questions, I thank you for the court's time.